The proposed bail reform legislation introduced by the federal government in May 2023 aims to reduce the number of people in pretrial detention and address racial disparities in the criminal justice system. The legislation would make it more difficult for some repeat violent offenders to get released on bail, especially if they are charged with serious violent offenses involving a weapon or intimate partner violence. The legislation would also place a reverse onus on these offenders, meaning they would have to prove why they should be granted bail, instead of the prosecution having to prove why they should not be. The bail reform is welcomed by officials in London, Ontario, who say that the city is experiencing an increasing incidence of violent offenders released into the community who engage in similar violent behavior while on pre-trial release. They say that the reform is a crucial and timely step that can protect victims and the safety of the communities. However, they also add that more will likely need to be done on the issue, such as prioritizing the rights of victims and providing more resources for mental health and addiction services. The bail reform is also expected to have a positive impact on reducing the overrepresentation of Black and ethnic minority people in the criminal justice system. According to data from the Met Police, Black and ethnic minority children accused of crimes are more likely to be refused bail by police in London than white youngsters. This increases the likelihood of them being remanded in custody for months until trial, which can have negative effects on their education, employment, and mental health. The bail reform would ensure that bail decisions are based on objective criteria and not on racial bias or stereotypes. The bail reform legislation introduced by the federal government in May 2023 has sparked a heated debate among different stakeholders, such as the government, the judiciary, the police, the civil society, and the public. Here are some of the main arguments for and against the bail reform from each perspective. The government argues that the bail reform is necessary to protect public safety and victims' rights, especially in cases of repeat violent offenders and intimate partner violence. The Justice Minister David Lametti said that the legislation would make it more difficult for some people charged with serious violent offenses involving a weapon to get released on bail, by placing a reverse onus on them to prove why they should be granted bail. He also said that the legislation would expand this provision to cases where the alleged crimes involve intimate partner violence, to prevent further harm to vulnerable people. The judiciary has expressed some concerns about the bail reform, saying that it could undermine the presumption of innocence and the right to a fair trial. Some judges have also warned that the bail reform could increase court delays and backlogs, as more people would challenge their bail decisions or remain in custody until trial. The Canadian Bar Association said that the bail reform could create more problems than it solves, and that it could lead to more wrongful convictions and appeals. The police have been vocal supporters of the bail reform, saying that it would address the issue of revolving door justice and prevent dangerous offenders from re-offending while on bail. The London Police Services Board and the former London Police Chief Steve Williams joined the calls for bail reform in February 2023, saying that it was a crucial and timely step to protect victims and communities. They also said that the current system was frustrating for police officers who had to arrest the same offenders multiple times for breaching their bail conditions or committing new crimes. The civil society groups have mixed views on the bail reform, depending on their focus and mandate. Some groups, such as the London Abused Women's Centre, have welcomed the bail reform as a positive advancement in protecting vulnerable people, especially women who face domestic abuse. They have also testified before the House of Commons on the need to prioritize victims' rights and safety in bail decisions. However, other groups, such as the Canadian Civil Liberties Association, have criticized the bail reform as a regressive and ineffective measure that would violate human rights and increase incarceration rates. They have also argued that the bail reform would not address the root causes of crime and violence, such as poverty, mental health issues, and systemic racism. The public opinion on the bail reform is divided and influenced by various factors, such as media coverage, personal experiences, and political preferences. Some members of the public support the bail reform as a way to enhance public safety and deter crime, especially after hearing stories of tragic outcomes involving offenders who were released on bail. For example, in December 2020, a suspected pedophile was able to re-offend after his bail restrictions lapsed. Other members of the public opposed the bail reform as a way to uphold civil liberties and justice, especially after hearing stories of innocent suspects who suffered under restrictive bail conditions. For example, in 2014, DJ Paul Gambaccini was wrongly accused of child sexual abuse and spent a year on bail before being cleared. The proposed bail reform in London aims to make it more difficult for some repeat violent offenders to get released on bail, especially those who are charged with serious offences involving a weapon or intimate partner violence. The reform would place a reverse onus on these offenders, meaning they would have to prove why they should be granted bail, instead of the prosecution having to prove why they should not. The potential impacts and challenges of implementing the bail reform in London are manifold. On the positive side, the reform could enhance the protection of victims and the safety of communities, by reducing the risk of re-offending or intimidation by dangerous suspects. The reform could also increase the confidence of victims and witnesses in the criminal justice system, by showing that their rights and well-being are prioritized over those of the accused. The reform could also deter some offenders from committing further crimes, knowing that they would face stricter bail conditions or remand in custody. On the negative side, the reform could face legal challenges from civil liberties groups or defense lawyers, who may argue that it violates the presumption of innocence or the right to liberty of the accused. The reform could also increase the workload and costs for the courts and the police, who would have to deal with more bail hearings and applications, as well as more monitoring and enforcement of bail conditions. The reform could also exacerbate the problem of overcrowding and delays in prisons and remand centers, as more suspects would be held in custody awaiting trial. The reform could also have unintended consequences for some vulnerable groups, such as ethnic minorities, low-income people or people with mental health issues, who may face discrimination or disadvantage in accessing bail or legal representation. Therefore, implementing the bail reform in London would require careful planning and evaluation, as well as collaboration and consultation among various stakeholders, such as the government, the judiciary, the police, the prosecution, the defense, the victims' advocates and the community groups. The reform would also need to be accompanied by other measures to address the root causes of crime and violence, such as poverty, inequality, social exclusion and lack of opportunities.